Okay, it is 4 o'clock. I will call the October 26th Salina City Commission meeting to order. I would first look at staff and ask if confirmation of the Kansas Open Meeting Act required notice has been properly provided.
Yes.
Thank you. With that, we will have roll call.
Mayor Hoppick.
Here.
Commissioner Davis.
Here.
Commissioner Franz.
Here.
Commissioner Hodges. Here. Commissioner Ryan.
Here.
Thank you. Will those who are able please stand for the Pledge of Allegiance and a moment of silence? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. Okay, well, that will move us into awards and proclamations.
Item 3.1, the day of November 1, 2020 as Extra Mile Day in the city of Salina. Brenda Gutierrez, Program Director at the Salina Area United Way, will read the proclamation.
Good afternoon. Brenda Gutierrez with the Salina Area United Way.
Brenda, you might pull that microphone down, please. There you go.
More like that?
That'll work better.
Right.
Thank you.
Yeah. Whereas Salina, Kansas is a community which acknowledges that a special vibrancy exists within the entire community when its individual citizens collectively go the extra mile in personal effort, volunteerism, and service. And whereas Salina, Kansas is a community which encourages its citizens to maximize their personal contribution to the community by giving of themselves wholeheartedly and with total effort, commitment, and conviction to their individual ambitions, family, friends, and community. And whereas Salina, Kansas is a community which chooses to shine a light on and celebrate individuals and organizations within the community who go the extra mile, all in order to make a difference and lift up fellow members of their community. And whereas Salina, Kansas acknowledges the mission of the Extra Mile America to create 500 Extra Mile cities in America and is proud to support Extra Mile Day on November 1st, 2020. Now therefore, I, Michael L. Hoppick, Mayor of Salina, Kansas, do hereby proclaim November 1st, 2020 to be Extra Mile Day. I urge each individual in the community to take time in this day to not only go the extra mile in his or her own life, but also to acknowledge all those who are inspiration in their effort and commitment to make their organizations, families, community, country, or world a better place.
Thank you, Brenda. Is there anything special scheduled for that day or some around that time?
Weather permitting. Thanking others who are really doing a lot by going the extra mile. Last year for the extra mile, an example is we did handwritten thank you cards to anyone that served as a volunteer on a county advisory board or a city advisory board. So as you can imagine, you folks appoint those, and over 200 postcards went out to thank. So looking back, that's something that we did in the month of November last year, and we're going to change that up a little bit this year with the C word, COVID and the virus, thanking folks that we acknowledge have gone the extra mile to help us all get where we are and moving things forward.
Well, Salina is blessed. I know this summer with COVID and with some of our budget restraints, we had a lot of individuals that stepped forward to help in different ways, and that's a perfect example of going the extra mile. And any of those that happen to be listening, on behalf of the city of Salina, we thank you for that. So, Brenda, I have a proclamation for you. Okay, that will lead us into the Citizens Forum. This is an opportunity for anyone who would like to come forward and talk about something that is not on the agenda. We ask that if you come forward, you please give us your name and where you're from. Okay. With that, we will move into the consent agenda.
Item 6.1, approve the regular meeting minutes of October 19th, 2020. Item 6.2, approve the special meeting minutes of October 20th, 2020. Item 6.3, approve resolution number 20-7890, authorizing the city manager to permit the Salina VFW Post 1432 auxiliary volunteers to solicit within the city's rights-of-way. And item 6.4, approve resolution number 20-7882, appointing members to various boards and commissions.
Okay, is there an item that any commissioner would like to have pulled off? If not, I will accept a motion to approve.
Mayor Hoppick, I move that we approve the consent agenda, items 6.1, 6.2, 6.3, and 6.4 as presented.
Second.
We have a motion and a second to approve the consent agenda items. All those in favor? Aye. Opposed? Those pass 5-0. Thank you. That will lead us into administration.
Item 7.1, resolution number 20-7893, authorizing the mayor to execute a former Schilling Air Force Base site environmental project management agreement.
Thank you, Mayor and Commissioners. Martha Tasker, Director of Utilities. The proposed former Schilling Air Force Base Site Environmental Project Management Agreement among the Salina public entities includes Kansas State University, Unified School District Number 305, Salina Airport Authority, and the City of Salina. And it provides the financial and administrative structure necessary to enable the Salina public entities to collectively complete the environmental response actions at the Schilling Air Force Base site. And it'll be in compliance with the 2020 consent decree between the Salina public entities in the United States and the consent agreement and final order between the Salina public entities and the Kansas Department of Health and Environment, who in this case is the regulatory oversight agency for this work. In 2010, the SPEs filed suit in federal district court alleging that under federal law, the United States was liable to the SPEs for past and future response costs incurred or to be incurred by the SPEs regarding the environmental contamination from the use of the site by the United States Department of Defense. The suit led to mediation efforts resulting in the 2012 consent decree, which was entered in between the Salina public entities and the United States. The SPEs assumed the responsibility for preparation of a remedial investigation and feasibility study under the regulatory side of the Kansas Department of Health and Environment. The cost for this project was $9.3 million, and 90% was funded by the United States and 10% by the city. KDHE issued its consent agreement and final order, ordering the Salina public entities to complete the remedial investigation feasibility study necessary for KDHE to develop its corrective action decision, ultimately selecting the remedy to be implemented in order to address the environmental contamination at the site. In 2012, the SPs entered into an interlocal agreement for the purpose of administering the completion of the remedial investigation feasibility study, all in compliance with the 2012 consent decree and the consent agreement and final order with KDHE. That phase of the project was completed on time and under budget, and KDHE then issued its corrective action decision addressing the remediation to be completed at the site. Following completion of the remedial investigation phase and the issuance of the KDHE CAD, the Salina public entities resumed mediation with the United States, which led to what we now call the 2020 consent decree. And it was approved by the Salina public entities at their June 24th, 2020 meeting, and just this week was approved at the final level with the United States Department of Justice. So one big step for the Salina public entities behind us. The Salina public entities and the United States will jointly take the consent decree for approval to the federal district court. Upon the court's approval, the Salina public entities will be responsible for performing all of the response actions identified in the corrective action decision. in exchange for the settlement payment from the United States. All this work will need to be completed in line with KDHE's issued consent agreement and final order. The 2012 interlocal cooperation agreement was structured in a manner that was prescribed by the Kansas Interlocal Corporation Act, which at the time was the most suitable statutory basis for an agreement among the Salina public entities, and was subject to review and approval by the Kansas Attorney General. In 2017, the Kansas legislature expanded the definition of municipality under KSA 12-2908, and they authorized any municipality to contract with any municipality to perform any governmental undertaking which each municipality is authorized to perform. This expanded definition of municipalities now includes all of the Salina public entities, such that the Salina public entities can enter into this management agreement rather than the Kansas Interlocal Corporation Act, and eliminates the need for involvement by the Attorney General's office. So now we're going to talk about the proposed management agreement, and it's a monumental effort by the Salina public entities and their legal counsel to get this document prepared. It's been a lot of hours of discussion and time. And this proposed management agreement includes 9 sections, 5 exhibits, totaling over 80 pages. So a lot of reading for you there. And I'm going to try to summarize some of the key points of that without hitting on every item, because I'm sure you all took time to read all 84 pages and have it clearly thought out. So at the end, if I missed something that was important to you and you want questions, we have several experts here that can help with the answers. The first section is acronyms and definitions. That's pretty straightforward. The second talks about termination of the current interlocal agreement, preconditions to commencement and duration. The 2012 interlocal agreement terminates upon commencement of this proposed management agreement. The proposed management agreement commences upon court approval of the 2020 consent decree and the Salina public entities receipt of payment of the settlement from the United States. And this management agreement will remain in effect till the Salina public entities meet all the obligations under the consent decree and the consent agreement and final order. Section 3 is no separate entity executive group. The SPEs authorize their respective chief officers to serve as the executive group. We'll discuss more detail on that in Section 6. Section 4 is purpose. The proposed management agreement provides for the administrative structure necessary to enable the Salina public entities to collectively complete the activities at the former Schilling Air Force Base site in compliance with the 2020 consent decree and the consent agreement and final order. This will be pretty similar to what was laid out in the previous interlocal agreement, so the purpose is very much the same. Section 5, funding the activities. This is an important section, and I'll cover the highlights of that, but there's a lot here to understand on what's going on. The estimated project costs for performance of the activities by the Salina public entities is $71.7 million, and those costs were identified in Exhibit 2 of this document. The proposed management agreement provides for the establishment by the city of a segregated fund to receive the United States settlement payment of $65.9 million and the federal funds remaining from the remedial investigation and feasibility study project, plus incurred interest, totaling approximately $67.9 million. The project cash flow summary, which is Exhibit 4, indicated Additional funding by the SPEs is not projected to be required for removal of the environmental contamination currently contemplated in the scope of work to be prepared in conjunction with the finalization of the consent agreement final order. The proposed management agreement does address the contingent need for additional funding by the SPs. The first case is when the scope of work is consistent with removal of the environmental contamination contemplated, and unexpected and/or additional costs are incurred in completion of the original scope, such that local funds are required. So additional funds are required. The SPEs agree that the city and the Salina Airport shall be jointly and severally responsible for paying all local funds necessary to complete that original scope of work. And the short story of that is the Salina public entities agree that Kansas State University and USD 305 shall have no liability to provide local funds required to complete the original scope of work. The second is when the scope of work, either as developed in conjunction with the finalization of the consent agreement final order, or it's amended based upon some future KDHE requirement, includes removal of environmental contamination that was not contemplated, resulting in future unexpected and/or additional costs, such that local funds are required to complete the scope of work. The Salina public entities agree to negotiate the allocation of such costs if and when those needs arise. The Salina public entities also agree that final preparation of the scope of work in conjunction with the finalization of the consent agreement and final order, any Salina public entity, upon written request within a reasonable time after receiving the consent agreement and final order, be given the opportunity for good faith renegotiation of the terms of these items we just discussed above. So, Section 6, Administration of the Activities, addresses how the activities to be performed by the SPE, Salina public entities pursuant to the CAFO, will be conducted. Just to be clear, the executive group administers all of the oversight for this agreement, and that group includes the CEO and Dean of K-State Polytechnic on behalf of KSU, the superintendent on behalf of the school district, USD 305, the city manager on behalf of the city, and the executive director on the behalf of the Salina Airport Authority. And they're delegated the oversight for the project. The SPEs will utilize a combination of a general consultant and specialized contractors and designate the city to be the contracting agency or the party, which is similar to what we did in the original project for the remedial investigation and feasibility study. The SPEs agree that the interests of their respective contingencies are best served by continuing to engage the Dragon Corporation as the general environmental engineering consultant. The city, in consultation with the executive group, is delegated the responsibility to negotiate the contract with the Dragon Corporation. And in addition, the city, in consultation with the executive group, will identify specialized contractors and contract with each of the recommended specialized contractors, similar to what we did before. There's a provision for potential work to be performed by Salina public entity employees. Haven't defined that specific work, but we have that opportunity in the case it comes into play. On the Exhibit 2, the cost estimate summary, the last item includes community involvement, administration, legal, and insurance. The next three items kind of pertain to that item. The estimated activity costs for administrative expenses, that's totally the executive group's responsibility to manage and utilize those funds. Reimbursement of the Salina public entities for environmental legal counsel and environmental engineering fees and expenses for work completed from January 15th, 2020 to the effective date of the consent agreement, which I believe will be sometime this year since the tolling agreement expires December 31st. And that's also a portion of that line item we discussed. And the other item is payment of the premium for the environmental third-party liability insurance coverage. 6.8 really addresses the work that the general environmental engineer and consultant staff will provide. Its subcontractors and specialized contractors will be under the oversight of the general environmental engineer. They will assign a designated project engineer for the project to communicate with the executive group. And in addition, they will maintain a field resident manager to coordinate all the on-site activities. Section 7 is termination, amendment, or withdrawal from agreement. Fairly straightforward. Section 8 is manner of acquiring, holding, and disposing of property. The Salina public entities don't anticipate separate acquisition or disposal of property under this agreement. Ownership of any personal property will be allocated by the executive group, and monitoring systems or other systems involved in monitoring the remediation or mitigation of contaminants will be regarded as part of the city's water and sewer utility system. Section 9 is general provisions, more typical agreement type language. Approval by the other Salina public entities have occurred by the USD 305 District Board of Education and the Salina Airport Authority's Board of Directors. Kansas State University Legal Counsel has approved the document and still waiting to discuss it with the president. Excuse me. As described in section 5.4 of this management agreement, the need for additional funds by the Salina public entities is not projected to be required. If contingent funds are needed for additional work, the most suitable funding source needed will be identified at that time. Leading up to this point, you may remember that we had kind of put a placeholder in the utility fund of $10 million, and the Salina Airport Authority has modeled and indicated a willingness to participate in cost sharing. I don't think I'll ever get used to sucking these masks and talking, so sorry for the tickle. As described in section 6.6 of the proposed management agreement, the city will be reimbursed for 1/4 of their environmental legal counsel and environmental engineering fees from January 15th, 2020 through the effective date of the consent agreement sometime later this year. Currently, the city's 1/4 share of these reimbursable expenses, it totaled $79,400 through September 30th of 2020. Staff has identified 4 options for the City Commission's consideration. Approve resolution number 20-7893, authorizing the mayor to execute the former Schilling Air Force Base Site Environmental Project Management Agreement. Approve resolution number 20-7893 with amendments as the City Commission deems appropriate. Postpone consideration of the resolution number 20-7893 to a specified time and date and provide staff further direction. Vote to deny resolution number 20-7893, which would result in the city being unable to participate and provide their city's obligation relating to the former Schilling Air Force Base site. Staff recommends option 1. As I mentioned, this management agreement is a huge team effort by the Salina public entities and their local council. This time I'll take questions, and if they fall in my area, I'll answer them. If they're best answered by one of the other team members here, Mr. Scragg, Mr. Binkson, or Mr. Rogers, we'll bounce the question to them. So this was a very lengthy document, but most of the information was important to make sure that you understand. So I'll take questions at this
Okay,
time.
who would like to start? Anybody have questions? I'll start to my left.
Where is the $10 million placeholder?
Where is it?
Yeah, you said it's in the budget. Is that a part of the cash expenses? Is that in the capital improvements program? Is it part of the rate study?
Yeah, it was part of the rate
study.
study. I believe it was in capital.
Okay, and it was presumed to be debt financed?
Yeah.
That's a question, not a statement, by the way.
Yeah, I believe so.
And to
So-
utilize some of our cash also.
Yeah, we had accumulated some
Combination.
cash balance
Okay.
in anticipation.
So removal of this obligation would free up potential resources in that fund, may result in changing the rate outlook on down the road.
Either the rate outlook or the capital expenditures, yes. And part of the decision we probably need to make going forward is whether we want to hold something in reserve just and wait to see how this plays itself out. Martha, do you remember the spend down? We've got a sizable percentage that will be spent down in the first few years, and then we'll know a lot more about what that budget might look like.
Originally, the thought for spend down was to, the larger share, probably 50-60% of the dollars would be spent in the first
3 years.
2-3 years, getting the processes constructed and in place. And then following that, it's more of a monitoring and
So my thinking is if we can get through those first 3 years, we'll know a lot more about, the cash flow projection and whether it's likely that there'd be any costs that we would accrue.
When you say spend down, you're talking about on the $71,700,000.
Yeah, the 68 essentially, but
Yeah,
yes.
yeah, the 60, yeah, okay, yeah, because there's an adjustment there,
in
sure.
Exhibit 4. And it does note that this investment and cash flow projections will be updated quarterly. So really, right now, we're a little early in understanding
Okay,
the cost of funding the project and the dollars spent and where we're at economically with.
yeah, I'm just trying to see when we can eliminate the placeholder and maybe reallocate those resources to something else we might need to do.
Right. I think we initially could downsize the placeholder, and then as we get a little bit further into it, we could potentially eliminate it.
Okay.
No questions here.
I did have a couple of questions. One, we just got notice that the consent decree's been approved, and it has to go to the United States Department of Justice for approval. Do we have any idea on the time frame on that?
Yeah, we had a call last Friday with our environmental legal counsel, and so it went through the Department of Justice approval process, and now there's a brief that'll need to be prepared by environmental legal counsel, finalized and submitted to the judge. And I don't recall, how long did he say it would take them? I don't recall off the top of my head. I do know that then the court will make a determination whether they want to conduct a hearing on it or whether they'll proceed without conducting a hearing. And they thought it'd be about 2 weeks or so from receipt or filing of that before we knew whether we were proceeding to a hearing or not. So all told, the thinking is to hopefully finalized by year end.
And once that's done, then they write us the check.
Correct.
Okay.
Yep. And then at that point, the blue sheet touches on kind of the effective date of this agreement relative to finalizing the court order and receipt of the funds. So this is all prospective that those dominoes fall into place.
And the Department of Justice has up to 90 days to make the payment to the Salina public entities.
And then we will enter into hopefully a contract with Dragon Corporation, and they will oversee the day-to-day operations of the cleanup, and that's the whole idea behind
They will oversee the design of those facilities, and I believe they'll probably have a subcontractor that may be overseeing some of the day-to-day efforts similar to what they did on the last project. And then they will also, as we mentioned, have a site person that's on there from Dragon to kind of oversee those efforts. But I think it'll be a combination of efforts.
And all those fees were taken into consideration in the 70 million?
Yes.
Okay. Okay.
With respect to Dragon, the agreement contemplates that they certainly have expertise. They were involved with kind of redesigning to reach this agreement, so they're, in my estimation, they have considerable ownership over the design and the cost estimating and implementation. But the agreement does provide an out if, for some reason, we can't come to a reasonable agreement with them. So if that were to be the case, we'd go through a competitive selection process at that point. But we'll be negotiating directly with Dragon unless that falls through.
Yeah, I would think as much time as they have involved in this, they would obviously.
Yeah, the consistency carrying forward versus bringing in another contractor that may not have, number one, knowledge, but ownership over this whole design and cost estimate is pretty significant in my estimation.
Okay, if there's no other questions, is there any public comment? Okay, with that, I'll bring it back to the commission for action.
Mayor, I move we approve resolution number 207893, authorizing the mayor to execute the former Schilling Air Force Base Site Environmental Project Management Agreement.
Second.
We have a motion and a second to approve resolution number 20-7893. All those in favor?
Aye.
Opposed? That passes 5-0, gets us one step closer, so.
And Mayor and Commissioners, if I may, I know you've heard this before and I know you know it, but this is very exceptional in terms of what it means for our community, the effort that a lot of people, Martha Tasker, Tim Rogers, and Greg Bankston in particular, have put in, including dating back to Dennis Kissinger and Jason Gage. And it's also pretty exceptional nationally for the federal government to basically cash us out and turn this over to us to manage is noteworthy. It's a sizable undertaking, but I think it is a success for this community in terms of being able to control the remediation, get it cleaned up, and part of this whole rationale was with this final payment, we can control our own destiny versus being in protracted negotiations and budgeting with the federal government for decades. This is very, very significant for the community.
Okay, thank you to all the entities involved in that, yes. Okay, that will bring us to 7.2.
Item 7.2, resolution number 20-7891, authorizing the placement of the 2019 People's Choice sculpture on the public property.
You don't look like Mr. Anderson. You're a lot better looking, a lot younger, so.
Mayor and Commissioners, my name is Jason Woolery. I'm the Visual Arts Coordinator for Salina Arts and Humanities. With me today is also Brad Anderson, the Director of Salina Arts and Humanities. Today is presented a request for placement of the 2019 People's Choice sculpture. In coordination with Sculpture Tour Salina, each year the city purchases the People's Choice Award winner. Once purchased, the artwork becomes part of Salina's public art collection. All 9 of the previously purchased People's Choice Award winners have been placed on public property or on private property with open public access to citizens and visitors. The 2019 People's Choice winner was Wheat Harvest by artist James Mages, a Kansas-based artist, and was accepted into the Salina Public Art Collection earlier this year, but it was not allocated a location for long-term installation. Because of stay-at-home measures through the summer and a lack of quorum by the Community Art and Design Advisory Committee, the sculpture has remained in its original install location at Assurance Partners on Iron Avenue. This action item is recommending a permanent placement for City Commission's consideration. After receiving consent by the Building Authority for requested placement, the CAD Committee and Arts Commission are recommending a site outside of the southern entrance of City County Building for long-term installation of the sculpture, as presented in the picture to my right, your left. As previously mentioned, the artwork has already been purchased. Installation expenses, estimated at $3,000, are covered through the allotted Arts and Humanities budget for public art care and maintenance. The following has been identified as possible options for consideration for the Commission. Acceptance of resolution number 20-7891 for 2019 People's Choice Sculpture, Wheat Harvest, for placement on public property at the southern entrance of City County Building. Provide direction to staff regarding an alternate placement of the 2019 People's Choice Sculpture, or deny the recommendation of this work's placement, resulting in storage of the sculpture until a suitable location is found. Now take any questions. That might be a
Questions or comments?
I think my only question concerns the ongoing maintenance of the sculpture, the public art. Will that fall on the city-county building, or because it's a part of our public art collection, is that something that we will continue to address through Arts and Humanities?
So Arts and Humanities will continue to do annual maintenance, just like on all the rest of our public collection.
Any other questions, comments? Okay, any comments from the public? Okay, if not, I'll bring it back to the commission for action.
Mr. Mayor, move acceptance of Resolution 20-7891 for the 2019 People's Choice Sculpture Wheat Harvest for placement on public property at the south entrance of the City-County Building.
Second.
We have a motion and a second to approve resolution number 20-7891. All those in favor? Aye. Opposed? Thank you. I can tell you for a fact that this was a popular piece. We actually had two businesses came forward and would like to have purchased it, but under our agreement with the artists, People's Choice, the city always gets first shot at it. So, okay. With that, we will thank you, gentlemen. With that, we will move to development business.
Item 8.1, consider request to terminate the protective covenants in the Holiday Resort Edition, a residential subdivision located on the southwest corner of East Country Club and Holmes Road. 8.1A, resolution number 20-7894, addressing the request to terminate protective covenants applicable to the Holiday Resort Edition to the city of Salina, Kansas.
Mr. Andrew.
Thank you, Mayor and Commissioners. You should have at your places a copy of a draft resolution that was prepared after the packet originally went out, and the idea behind the resolution would be that it would be appropriate instrument by which the City Commission could make its and record its findings as it relates to this matter. The Holiday Resort Edition is located near the southwest corner of Country Club Road and Holmes Road, near the former Parsons School that's located in that area. In 1993, that property was outside the city limits and was unplatted and not zoned. It was an agricultural piece. There was a proposal put forward to construct a holiday resort nursing home on that property, and it became a mixed-use planned development district, which involved construction of a nursing home, potential future assisted living complex, which has not been built, and there was also the platting of 23 residential building lots. It was a fairly controversial rezoning case. The Planning Commission actually recommended denial of the zoning change. The City Commission ultimately approved the zoning change, as well as annexation and a final plat of the property. And then at the August 23rd meeting, there was a fourth action item on their agenda, and that was to approve a set of covenants and to ensure that those covenants were recorded with the final plat. The unusual aspect of that was the fact that the covenants were made so that they were enforceable by the city of Salina and cannot be amended or modified without the prior approval of the governing body. And so there were concerns, first of all, as to whether the types of homes developed in holiday resorts would be compatible with the homes in Country Club Estates number 4, which is directly to the west. There was also concern about the enforceability and how likely it was for those covenants to be enforced. And so the covenants were endorsed and approved by the City Commission. And we have summarized for you Section 23 of the covenants, which gives authority to any person or persons owning property in the subdivision or for the City of Salina to enforce any violations of the covenants. From that point in time, the city has done its enforcement through the building permit review process. Brad and Crystal Blocklinger they purchased a home in 2019 at the northwest corner of Eastmore Drive and Deborah Drive. This is a corner lot with a ranch-style home. It already has an attached 2-car garage. And they submitted a building permit application to construct a 24 by 32-foot detached garage west of the house. Staff informed the Blocklingers that we could not issue a building permit for the proposed garage because to do so would violate the protective covenants in the Holiday Resort Edition, which only allows attached garages. So we've summarized that language for you. This restriction on detached garages is consistent with the restrictions in the subdivision directly to the west of Holiday Resort, which also does not allow detached garages. So what we've done is not issue building permits for construction that's contrary to what's allowed under the covenants, and this includes permits for detached garages. The city has not issued any permits for detached garage in this subdivision since the covenants were first executed and recorded. There was even a building permit denied on this same lot to a previous owner. Mr. Blocklinger indicated that he and his wife were unaware that there were protective covenants, and they asked city staff what their options were in relation to that. We discussed 2 options. One was to amend the covenants to allow detached garages, or the second option was to simply terminate and release the covenants. The Blocklingers perceived in talking to some of their neighboring property owners that there was more support for terminating the covenants, so that is the option that they chose. There are 23 individual building lots. The covenants provide that the covenants remain in effect unless by a vote of the majority of the then owners of the lots it's agreed to change the covenants, each lot being entitled to 1 vote. So with 12 individual lots, that means at least 12 property owners have to believe and agree that the covenants no longer serve a useful purpose and should be terminated. The release of the covenants also has to be approved by the City Commission, and the document terminating the covenants would need to be recorded in the Register of Deeds office. So this is coming back to you partially because in November of 2019, you considered a request in a slightly different form, and you passed a motion to postpone this item to allow staff to conduct research on the item and return the item to the City Commission at a later date. So this had been before you once before, and you postponed consideration, and so this is being brought back today with our research and with an update of what has occurred. So as we noted, it requires the majority of the property owners to have the property covenants released and terminated. There is no homeowners association, so there's no organized group. That's normally how something like this would be handled, but in this case, city staff and city legal counsel did help by ensuring that the document that came before you today was a legal recordable form that's in a form ultimately in place for your consideration. City staff also assisted by preparing a list of current property owners. City staff also assisted by sending out a mailing, which is attached in your packets. We mailed that letter to all the property owners in the subdivision to assist them with making a decision as to whether they wanted to keep or terminate the covenants. So we summarized on page 3 there the information that we sent out to each and every property owner. And in some cases in the past, we have helped host or found a location for a neighborhood meeting. In this case, we felt like going door to door was not the best option. So to maintain social distancing, we set up a time and place where property owners were invited to come in. If they were in favor of eliminating the covenants, they could come in and sign the document. And we also had a notary on hand so those signatures could be notarized. That event took place in room 107B next door on August 27th. We had 10 owners come in and sign the document. Block owners then went out and obtained 2 more signatures, bringing the number to 12. Following delivery of that document with 12 signatures, city staff received a notarized statement from an owner rescinding their signature on the termination of the covenant, stating they didn't understand the full scope of the signing document and then felt misled into signing it. The city attorney has reviewed both of those rescission documents and found them valid to form. So that if you accept those as valid, then the number is reduced to 10. Mr. Blacklinger went out and obtained 1 more signature from Kevin and Della Berger, but they have since submitted a written affidavit stating that their signature was not notarized at the time that they were asked to sign it. So the original document has 13 lot owners of the 23 with signatures on it, but we've now received notarized statements with acknowledgments seeking to rescind those. If we accept and recognize those withdrawals, that leaves us with only 11 of the 23 lot owners, which is fewer than the required majority. The city attorney has reviewed those and has advised staff that both the termination document and the subsequent withdrawals should be presented to the city commission to allow you to accept and determine the effect both of the termination document and the subsequent withdrawals. Therefore, this has been placed on your agenda for this evening. The city's legal counsel recommends that the termination document and the subsequent withdrawals be accepted and recommends that the following findings be made. That the 2 rescission statements from the property owners have been timely filed prior to your consideration of the termination document, and that the 2 statements have effectively withdrawn the signatures of the 2 lots from that document. So if you find those to be effectively withdrawn, there are not enough valid signatures. Conversely, if the rescission statements are not found to have effectively withdrawn the signatures, then a majority of the lot owners are represented on the termination document, which meets the threshold for your consideration. Staff does want to note, and we've tried to make this clear, but we'll state it again, regardless of the number of signatures, even if it was close to unanimous, the city commission is not obligated to terminate and release the covenants. It is a discretionary decision for the commission. So whether there's 12 or 13 or 15 or 10, if it's under the majority of 12, there's no way for a document to have any effect. But if it's over the majority in your view, you are still not obligated to terminate the covenants. So we've identified several options. If you concur with the city's legal counsel's recommended findings, you should make a motion to approve resolution number 207894 as drafted. And as drafted, that resolution indicates that you accept the termination document and subsequent withdrawals, and that you find that the 2 rescission statements have been timely filed, and that they have effectively withdrawn the signatures of those 2 lot owners from the document, and that would deny the property owner's request and deny the termination of the protective covenants. If you find that the majority of property owners are represented on the termination document, then you should direct staff to modify that ordinance so that the resolution can authorize the mayor to sign the termination and release document. The third option would be to postpone consideration of this matter to a future meeting date if additional information is needed from staff or property owners within the subdivision to make a decision. I would note that there was a lot of back and forth for this item that has occurred since August 27th. And so what staff did was gave a hard deadline last Monday at noon. No more additional signatures, no more additional rescissions, no more additional submittals. And so nothing has changed since noon on October the 19th. And so the documents that are in your packet have not changed since that time. With that, I'd be open to any background questions. If you have any legal questions, I would refer those to Mr. Bankston.
Well, I don't know if it's legal or not, but is there any reason we wouldn't accept the rescissions, the request to remove their names from the petition?
I am unaware of any reason that you would not accept those rescissions. It was simply a matter of recognition that we needed to present to you what was available and seek your direction on that question.
I have a question. They are 1 short of the number of signatures to compel this to happen?
Does not compel it to happen.
Okay.
It allows it
to happen. But if they are 1 short, we don't have a choice. We cannot allow it to happen.
If you agree that the termination, that the withdrawals of the 2 signatures make it less than a majority, then you would be compelled not to approve the termination. If you find that the termination, that the withdrawals are not valid, you still have a discretionary decision whether you think it's in the best interests of the public or the subdivision as a whole whether to terminate. So you're not obligated to terminate the covenants if there is a majority, but it would have no effect for you to vote to terminate the covenants if there's less than a majority, because the document, if recorded, would be ineffective.
Okay.
If I may,
I do have a question about the Burgers document then, because it says they contacted us later and said the notary did not witness the signature, but in the blue sheet it states the notary does not have to observe the act of signing, but does have to be in the presence of the signatory when the signatory acknowledges the signature is his or hers. And on that notarization, the notary indicates that it was acknowledged in their presence. So is that withdrawal valid or not valid? I'm really confused by that.
I don't,
No. Commissioner, the reference to that circumstance of the question raised about the notary was informational. That signature is not included in the math as to the withdrawals. There are a total of 13 to begin with. The 2 were just simply acknowledged requests to withdraw, the owners of the 2 lots.
Right, okay,
That's what brought it down to 11,
okay.
below the necessary majority. As I say, the discussion about the notary on yet the separate signatures, and I'm sorry, I've forgotten the lot owners' names.
The one in question is Burgers.
Yes. The Burger lot was not included in the math.
Was not included in the map?
In the math,
Okay,
sorry, the MATH, yeah.
okay.
That takes you from 13 to 11. It was simply a discussion to advise, and frankly, if we needed to go to that issue, the point was that that is correctable if the Burgers presented themselves before a notary public and said and acknowledged that that was their signature. A notary could notarize that statement as an acknowledgement of that being their signature. And I'm sorry, I realize that.
Okay, so the Burgers were on the original petition.
They were not.
No.
They were not. So the way that you can tell that is if you look at the termination document, you will find that 10 of the signatures on the termination document were notarized by Allison Ham on the 27th of August. And Allison Ham is a city employee, and I also witnessed every one of those people sign the document. There were 10. Outside of our signing event that we had here, the Blacklingers obtained 2 additional signatures by going door to door. Those signatures were notarized by a Krista Long. And then most recently in October, the document was taken back out and the Burgers signed it. Their signature was notarized by a Krista Long. And after they signed it, city staff received a notarized statement signed by the Burgers that said that they wanted it to be known that their signatures were not signed in front of a notary public. And so, as Mr. Bankston said, for purposes of determining a majority of 12, we didn't remove the Burgers from that number.
So if they were not signed in front of a notary, why do we have a notarization?
Well, that's a good question. And
I'm at a loss because that makes a difference.
Well,
but
it doesn't,
if,
actually.
If the Burgers went forward and remedied the notary issue, the number of signatures would still fall short of the number needed to have a majority.
And the reason we simply noted that was, again, the math on meeting the requisite majority is not affected by the Burgers' signatures.
It is not.
It is not. There's 13 lots represented. If you just take the termination document on its face, there are 13 lots for which the owners have signed and the signatures have been acknowledged. There are the owners of 2 lots that have come forward and given notice of their rescission of their signature, which gets us from 13 lots to 11.
To 11.
Which does not meet the requisite majority for consideration.
Okay, and the requisite majority is 12. Is that correct?
Correct.
But then the Burgers come along and they sign this.
Now, we're counting the
They're
burgers
part
in
of
the
the
13.
They're part of the 13.
Yeah.
The burgers are in the 13. Because the status of the burgers' signatures had not been conclusively addressed, we did not, as staff and as council, did not speculate as to the status of the burgers' signatures.
So they're
Or- and
a
did
part,
not
of-
base-
they're already a part of the 11. They were not
If you
an
look at this, they're the
add-on.
second, they're the top signature
Well,
on
yeah, I
page
see
2.
them
Okay.
there, but I don't
Yeah.
understand why we went through all this discussion about, the additional and their withdrawal.
Well, because the document started with 13 signatures, the Burgers raised the issue of whether their signature was notarized or not. So we felt like that needed to be shared with you. But as I said earlier, the Burgers are counted towards the 13. They're not part of the 2 that are removed to get to 11. And so whether their signature was notarized or not, even if that is remedied, you're still left with 11 signatures.
Okay, and if it's not remedied, then we're left with 10.
Correct.
Okay, thank you.
So if I may, another point of clarification, I think reference was made to you as the governing body approving the termination. If this document had the correct number of signatures, you're not in a position to approve or deny the termination. You're in a position of consenting to the termination as a party to the covenant. You're not in a full, approval role. We, in 1993, were made a party to the covenants along with the homeowners, and your role is, if the termination were perfected, which we do not believe that it is, you could either consent or not consent as a
Okay,
party.
I get that. So the question is, if we don't have an option of actually making a decision, why is it in front of us?
I'll be happy to answer that. And I understand that's a totally understandable question. I recommended that it come before you for 2 reasons. One, when you initially considered the matter, you directed that it be brought back to you. And secondly, I did not regard myself in my role, my advisory role, of being in a position to make a determination, as a matter of fact, of whether the city accepted the signature rescissions and expressed my thought that really it seemed to me to be a governing body function rather than even a staff function to bring to you the facts of the matter as they are presented, particularly since it had been directed that it be brought back to you, and that as the governing body, it was your role to evaluate the information that we now have regarding this matter. And that's what led to my recommendation that it needed to be brought back before the governing body.
So our real choice is to consider the reasons that the signatures were rescinded and determine if we think they are valid or not valid and whether or not to accept those rescissions.
If you wish to go that far in the analysis, I suppose that is your prerogative. As I indicated, I believe they are valid as to the form. They are properly stated. They are properly acknowledged. And from that standpoint, they presumably represent the intent and desire of those who signed the rescissions. I might point out, and hopefully this is helpful too, the reason for the language in section 3 of the proposed resolution is that if the rescissions are accepted, it becomes, the question really becomes moot. And that's the reason for the description in section 3 that if you choose to accept the rescissions, that in section 3, it indicates the governing body therefore concludes that the question of whether the city consents to the termination document is rendered moot. It is, I think, if you accept those rescissions, a moot question, and it's in practical effect that the request of the applicant is denied by virtue of the mootness.
And your, I don't know if to call it a recommendation, but your statement as the city's legal counsel is that indeed those rescissions are proper, and we really have no grounds for saying we're not going to accept them.
That's certainly my view of the matter, and part of that, as you might expect, is given that they were delivered and provided in advance of your consideration of the matter. I think there's no, I don't know of any law that dictates exactly where that line is, but it seemed as though notification of a rescission prior to your consideration of the matter would be deemed timely.
Okay, thank you. I had two more questions, but by now I've forgotten what they are.
I just wanted to clarify that the provisions that say that certain protective covenants can't be amended without the governing body's consent is not entirely unusual from the standpoint if you have a residential subdivision and that residential subdivision has covenants that obligate the property owners to maintain the private streets in those subdivisions. We don't want the homeowners association to unilaterally amend the covenants and turn that responsibility over to the city without the city commission consenting to that. So that particular language about the consent is not unusual. What is unusual in this case is that the city is an actual party and enforcer of the covenants.
I had a couple of questions more generally than I think specifically to this, but do we hold that position in very many other subdivisions in terms of the role that we play?
This is the only one that I'm aware of in my experience where I'm actually keep a copy of the covenants at my desk like the zoning ordinance, and when I have a building permit, I review those. I don't do that in any other subdivision.
Okay. And then I'm not sure who this question is for, maybe for the mayor, but when someone purchases a property like the Blockling did, they indicated in their correspondence that their realtor didn't know about it, it wasn't disclosed to them. At what point would that typically happen that you know you're purchasing a property and somebody says, oh, by the way, there are covenants in here?
Well, I'm sure the mayor can speak to that because of the vast number of residential closings that he does, but in an ideal world, the realtor who has the property listed would disclose, would be knowledgeable about whether there's covenants or not covenants.
Do their due diligence,
or whether
in
the
other words.
streets are private or public, and they would disclose that to the buyer. But in that case, it didn't happen. On the other hand, every property buyer gets a title report prepared by a title company, and that title binder or title report will call out things like covenants, easements, things like that on the title binder. Often they're on page 2 or 3. The other thing is that oftentimes those are handed to them at the closing when the decision has already been made to purchase the property. So
I got you. So really,
yeah.
it comes down to the person representing the property for sale.
And this has been an ongoing thing. If you drive around the community, you will, particularly say on Marymount Road, you will see if you drive down Marymount, certain street signs are green and then certain street signs are white. And so what we found was that a lot in the realtor community were not disclosing to people that their subdivision had private streets that they were to maintain. So one of the things that was done is that private streets have white signs and public streets have green signs. so that even if it's not disclosed to the buyer, you can look for yourself and say, that has a white sign. That means the city's not going to maintain that street, and that I would be obligated. So that was done by the Planning Commission partially in response to complaints and concerns received that no one told me that the streets in my subdivision were private.
Thank you. That's all I have.
Any other questions or comments?
And I didn't know if you wanted to amplify on that, if I correctly described the closing
Yeah,
process, but I
And
have sat down with people and
I believe I
showed
can
them.
comment on this because I didn't do the title work. So I went back and looked to see, but yeah, the title company that did that, there should have been a commitment that was issued that would have showed plating, covenants, restrictions, all that on there. And then on the final, on a B2 and then on a final policy, they should have been listed also, so.
Thank you.
Having said that, having bought homes, it can be overwhelming. That process can be overwhelming. There can be a lot of paperwork, and you well know me. I'm the guy that says, hang on a second, I want to take a look at this, and there's a lot to go through. It can be easily overlooked in my estimation.
But in an ideal world, people who are looking at a property, that the realtor who's listing the property would be knowledgeable of that and share that with the owners. I saw the report that was prepared by the sellers in this case, and then the box where it indicated, is this property subject to restrictions or covenants? It was marked no on the information filled out by the buyer or by the realtor, but nonetheless, the covenants were recorded and of record. The other thing is, I think when I look back in 2009, there was a building permit applied for at this address for a detached garage, which we also turned down because of the covenants.
Dean, you said the information filled out by the buyer, but I assume you mean the seller?
Yes, I meant to say by the questionnaire that was filled out by the seller of this property that owned it before the Blocklingers purchased it. They provided me with that form, and whether it was filled out by the realtor or by the sellers, the box where you indicate yes or no, whether there were restrictive covenants, the box was marked no on the form.
Okay, I remembered my other question. The Blocklingers submitted us a document with a number of pictures that purport to show a number of covenant violations in the neighborhood, and I don't know that that has any effect on how we treat this decision. But are those valid concerns? And if we're not able to enforce those, then
I'll try.
And I'm not sure where I'm going with that. It just strikes me that if these are valid concerns, then it seems like we have work to do. Right. To try to get better at enforcing those.
Well, staff had a conversation about that and what enforcement looks like. And as Dean mentioned, our interest is to protect the city's interest, whether it relates to plating or whatever assertions were made at the time the Planning Commission said the covenants are important. So that doesn't mean we necessarily have an interest in landscaping or trailers or parking as much as plating and some of the other elements of the subdivision. And if you look at that language about enforcement, it's really pretty standard language that any party to the covenants can pursue enforcement by legal remedy. It doesn't necessarily empower the city to have extraordinary enforcement powers beyond what an individual homeowner could do by taking their neighbor to court. I view our role and what Mr. Andrew's been doing with it in terms of the building permits is we're a party to the covenants. We don't want to be party to a violation of the covenants. So we're not necessarily enforcing them, but we have a dual role as a party to the covenants and issuing building permits. And we're not going to issue a building permit knowingly violating the covenants.
That violates the covenants.
But we're not necessarily going to patrol the residential neighborhood and enforce them in their entirety.
But as within any restrictive covenant, enforcement of those covenants is actually a responsibility of the residents in the neighborhood or the homeowners association. So if these improvements that purportedly violate the covenants do so, then any of the neighbors could have taken action to keep that from happening or to have it repaired.
Correct.
And I suppose if we knew about them, we could too. Of course, we'd have no reason to know about landscape changes and so on.
Correct. Now,
Outside of zoning requests.
The one assertion that there's 4 cars in a garage, that could have been something we overlooked at the building permit. The remainder of that, I think, is between private parties.
Okay.
That modification was actually approved by the city commission in 2007 for the 4-car garage.
Were we aware at the time that that was prohibited by the covenant?
Yes.
But I think, if I understand this correctly, but what the people back in 2007 were asking for was a one-time exception, basically, and what we're looking at now is just to eliminate the covenants altogether. Am I characterizing that? I can't talk correctly.
The approach that was taken in 2007, the legal counsel has advised me that that approach was taken at that time was probably the incorrect mechanism by which to do that, but it did not happen unobserved. The item did come before the governing body, but the same thing that we're discussing here is what should have happened then and didn't happen then. So it wasn't the fact that it was unnoticed, it was the fact that we didn't address the issue correctly in 2007, and we are correcting that now.
Okay, if there's no other questions for staff, I'll open it up to the public if there's anyone that would like to comment. Please state your name and where you're from.
Brad Blocklinger and Crystal from here from Salina. A couple things. Dean mentioned originally that we had signatures. Back in February, me and my wife walked the neighborhood and received signatures. We had 2 different forms. One was to abolish the covenant altogether, which we got 12 signatures for that. And then we got 15 to amend it to just so we could build the detached garage. I had more approval for that. There was a few people that said, I don't want the covenant to go away, but I have no problem with you guys building a garage. So I'm not sure if I misinterpreted that or didn't tell Dean that correctly, or he just misunderstood me, but that's the way we went. And I don't want to blame this on Dean, but I was going with his advisement, and I took it as that you guys really don't want to mandate this anymore because there's so many violations, as we've been noted, that is not being enforced. There's an empty lot there that's set open for 25 years since this covenant come in place, and they have 6 months to build on it, and nobody's built on it. These owners own the house on Presley, and they just have a garden there, half of the lot or a quarter of the lot or whatever. And so that's pretty easy to spot just by driving by. And there's been nobody to regulate that, nobody to say, hey, you've had 25 years, let's get it sold, build on it, something. So it's kind of disheartening that you have to have a permit before any of this comes to light. As far as the Booger's signature, I always want to clear up. I wasn't trying to do anything shady. My notary that I brought had back surgery 2 days before, and she was in the car. She seen the paper that wasn't signed. She watched me go to the house, come out, and we just walked down the sidewalk, and it was signed. So she knew, obviously, and she seen Mr. Berger open up the door, and I was in there talking to him for quite a while about other stuff. But so that's what we took as she witnessed it. She just couldn't get to the door very easily, and she said, well, I'll just stay here in the car. I'm really hurting. So that's how that came about. And we had a deadline date for signatures to be turned in. And I had followed up with Dean on when we were coming to in front of you guys. And he said, well, we've had a person recant their signature. So we're going to be down to 11, and you'll need to go either get somebody else or, whatever you can. So I went to the Burgers Inn and applied that. I did not know till today when I got the email that there was 2 taken out. So, and I didn't turn the signatures in until the day of the deadline, that additional signature. So were both of them recanted at the October 9th deadline or whenever that was? Because to my knowledge, or maybe it was October 7th, I believe, was the deadline at 5 o'clock. I did not know about that. Really, I just want a detached garage. That's all we were wanting. Like Dean pointed out, in our closers or sellers closers, it was marked no HOA, and in the next box was no governing body. And the real estate company was the buyer and the seller. It was the same company. So whether that whole company as a whole didn't know it at the time, but that's why we were under the assumption we could build. I don't remember signing it. Like I said, we have so many papers at the time of closing. I don't believe that was ever brought up to us. And I guess the signatures that were recanted said they were misled. I would like to know how they thought they were misled. They came down here. They had the same packet that everybody else. I sure didn't tell them anything different that was on the packet. And it seems like there's been 3 people that's been approached. I know there's some homeowners that are against this covenant to go away that have made a point to go talk to the other residences, which that's a prerogative. I wonder what was told to them to convince them that this is not, something that is best for the neighborhood. Because they signed, both these people signed in February. I didn't have it notarized at the time. I still have the paper that everybody signed, but me and Dean miscommunicated there. I thought it was just, he gave me a form of all the residences, and so I just had them people sign under their name at each place. And then he's like, well, that's not a legal document. We have to have it notarized. And that's when we came to going down here. And mind you, this is back in February. And I'm at everybody's houses a couple times. We walked the neighborhood several times getting signatures. And then so I had, people went out of their way to come down here to sign, and then all of a sudden, a week or 2 later, oh, we don't want our signatures in there. So it doesn't seem quite right that they went out of their way to come down here to sign, and then all of a sudden, we don't want to have the signature anymore. So, it's kind of odd that something was said to talk them out of it, and whether that was true or not, nobody's going to know that. So, if the covenant, if there's not a signatures or whatever the decision is there another route we can go to just amend it? Like the house that has the 4-car garage, it was the one-time amendment so he could add his 4th stall. He already had a 3-car garage. He just added another stall to it. I would like to just amend it so I can at least build the garage. The covenant, like we said, really isn't enforced, other than when you need a permit. So I wouldn't need anything else because the landscaping and everything that's been brought up isn't really enforced by the city like I read the covenant to read. And
I think depending on the decision made here today, if you looked, if you want to address in a different direction, I would say you need to take that conversation up with Mr. Andrew.
okay,
So
that can't just be brought up today too with it.
I don't know if we want to, I think we're dealing with this today. I think you'd need to talk to Mr. Andrew about what your options are, if you
Okay.
have other options. Yeah.
Right,
Yeah,
okay.
I think we're headed down the signature route for amendment.
Yeah.
And then in answer to your other question, it looks like the two rescission documents were dated October 1st and October 7th.
Yeah, I looked.
Okay.
If I might pursue, though, I do have a question. You said that when you started this, you were looking at both requesting an amendment and a rescission and, or a termination, and you actually had more support for the amendment than you did the termination. Okay, but you elected to pursue the termination based on Mr. Andrews' advice?
Yes.
Okay.
Simply because he was under the impression that, you guys are no longer wanting to govern this anymore. It's it's the only one in town or the second. I don't know. I thought there was one on Pine Ridge, but maybe I was mistaken on that.
Okay, thanks.
But at that point, there were enough signatures for either option?
Yes, there was.
Okay, so nobody had actually put their name on the paper saying we're okay with this in either case?
Yes, they did. Yes, they signed it. It just wasn't a official form that had
Okay.
been notarized.
Okay.
But
So,
All
so
right.
correct me if I'm wrong, but the assessment at that point was you had a majority for termination and you had even more in support of amendment rather than termination.
correct.
So,
And so our choice was to proceed with the termination.
well, the advice was, if there's support for termination, that
By all
cleans up the
means,
record.
let's do that. And that was
most pristinely.
based on our interest in not wanting to enforce it anymore?
Well, I think for clarity, if you've got a majority of the people that are willing to terminate it, then it's a non-issue at that point.
Unless somebody steps forward and rescinds it.
But we don't,
Well,
we
I
don't,
don't think we anticipated that, no.
Okay, all right.
I think that was part of it. With respect to enforcement, amendment would have taken us out of the enforcement role, or termination would have taken us out of the enforcement role.
but we're not actively enforcing the covenant per se. We're a party to prove something, but we do not go around to make sure, it's not our job to make sure that it's being enforced. Is there a homeowners association that does that?
Not a functioning one.
That might be a problem that needs to be corrected before you go any further.
Originally, I think the covenant stated that there was a committee, and it had 2 or 3 people in this committee, and I think they were kind of in charge of. I believe they lived in the neighborhood at the time. I don't think. In fact, I know them names aren't any of the homeowners now, so they've either.
Has the committee met in the last 2 years?
Sorry.
Has the HOA met in the last 2 years?
No, I think that covenant or that committee is void. Because like I said, this was 25 years ago, this committee of the 2 or 3 people, and them names aren't even in the home on the ownership anymore. So, and after the 25 years, it says you can go down to 10 years. Every 10 years this gets reviewed or whatever. Well, that was in sometime in 2019, I believe, and that didn't happen either. There was no review process to say, hey, this committee is no longer intact. These people aren't in this neighborhood anymore. Why don't we have something in place? So.
And that's not an entirely uncommon occurrence for homeowners associations, unfortunately. It's kind of hard to maintain that organization and momentum.
So whose responsibility is it to resurrect it?
The homeowners.
But wouldn't that have to come to a vote also? Something, because there's no homeowners association.
I think I've reached the limit of my legal knowledge on this one. How do you reconstitute? I'll turn to the city attorney.
Generally, those take the form of a Kansas not-for-profit corporation, which I assume does not exist if it ever, no longer exists if it ever did. So basically, it's a matter of organizing under a not-for-profit corporation to operate as the homeowners association. That's generally how that would occur.
Any other questions for me? I don't think I have anything else.
Okay, thank you.
Well, is one, I wouldn't personally worry so much about why the two people rescinded their signatures. I mean, I wouldn't want you to think that you had neighbors who were misleading them, because they could take the same argument that you misled people into signing. So for whatever reason they wanted to change their mind, they were entitled to change their mind.
Yeah, they were just, I didn't mislead anybody from the, because they had the packet, and, you know, I just, some of them, one of them, I didn't even go to the door. They just came to the signing. So, but anyway, okay.
And if you ever see our meetings, well, I'll speak for myself again, I changed my mind a lot.
Okay. Thank you.
Thank you. Yeah, anyone else?
My name is Ken Creer, 2730 Deborah Drive. I'm directly across the street from the block linkers. I would like to address your question, if I could, about the notary public. I called the state of Kansas. 101 they stated is you have to be there and witness the signature. So that's, for that I can answer that. Okay, I'm not sure, as we've discussed, why we're really here. And I've talked with the city attorney on this, because they don't have enough signatures. That was very clear in all the forms that came from the city. So, and I was a realtor, and I'm very aware about covenants. They're really easy to slip through. That's why you're supposed to do your due diligence. Now, this broker, or realtor, was also a broker, so he's well-educated beyond that. So if anybody should have known that, that would have been something he should have done. I have been told that when they found out that they had sold them a lot, they came to them and said, we will allow you to pick out another house, lot, whatever. We'll move you to no cost through the realtors. So that's kind of a moot point to me. When people look at houses, they go out and try to find a house that they want, in an area they want, in a price they can afford. And that's normally what people do, and then they get to the papers. We had a nice neighborhood. They chose to come into the neighborhood. We're glad to have people there. We want people to keep the neighborhood up. In the covenants, it says no detached garage. Yes, there is one 4-car garage, but it's not detached. This is going to be a 24 by 32 garage. It's going to be a big shop. He also has worked on his car. He has a race car. He was out in the driveway the other day, beating on his truck, taking a dent out of it. So that's what we're going to have in the neighborhood. There also, if you look to the reading of the particular wording in the covenants, there's some question about it. Several of us got together and visited about it. We thought the wording was interesting, so I went to an attorney, we went to an attorney, and asked, and he said, yes, it could be very well interpreted as you said. So I go to Mr. Bingston and ask him how to read it, and I showed him how we read it. And he said, so why are you asking? And I said, because we're questioning it, and I visited with an attorney. Well, as soon as I said that, he was done. He just said, you know, I can't commit to anything. But according to our attorney, the wording is so that they can't change the covenants for the next 10 years. It's 25 and in segments of 10. So that's where we are with that. No one in the neighborhood wants the detached garage. I mean, it's going to be a 24 by 32. It's not just a little garage that's attached to your house. I wanted a garage to my house. Last year I built one. Cost me a lot of money to have the whole front of my house re-bricked so it all matches. I also wanted a 24 by 32 building. I couldn't have it, so what did I do? I went down on Jewel and purchased a piece of property where everybody has a garage in their backyard, and I put my garage down there because it's okay. So So those are all the reasons, I think, but the basic one is they just don't have enough signatures, and it wasn't really explained to the people. The other thing we question is that they had a deadline, came down here, he had 10 people come down and sign, which is great. But then when he didn't get the signatures, they allowed him to go ahead and go door to door, which was the exact thing they didn't want to do in the first place. So I just question that. Thank you for your time.
Thank you.
Hello, my name is Rick Nicholson. I live at 143 South Presley Drive. The garage that proposed to be built will be built in my backyard. My wife Bonnie and I purchased a home about 5 years ago. We moved to that area because it was quiet, it was nice, there wasn't a lot of traffic, and people took good care of their property. We've enjoyed living there. We spend a lot of time on our deck, eating barbecue and playing with our dogs and stuff. Although it's a small view of the country, the garage, and it's not really a garage, it's a big metal building, would block our limited view of the countryside, which we do enjoy looking at. It was kind of funny. One time I said to my wife, I've got a few cars stashed around town, and I said, I'd like to build a garage back in my backyard, which I have room. She said, you're not going to do that here. This is a nice neighborhood. And it is a nice neighborhood. And I probably would never have done it for that reason. It kind of takes me to the past a little bit, and how rules affect people in a town. My first house I bought was on 861 Windsor Drive. Just a little house. I was a bachelor, so what difference does it make? But my neighbor all of a sudden parked a big old 40-foot trailer in his front yard, right parallel to my driveway. I complained about it, and I said, well, that's illegal. Next thing I know, he's pouring a slab under it, and it's parked there. So I step outside my house. I see the trailer like I'm going to see this garage. But it also, so I looked at it every day of my life. It blocked my vision of the traffic. So I backed my car out. I couldn't see it. And it created a big old snow fence. So on days like this, I'd be shoveling snow out of my driveway. It used to, blow on by. So it's just an example of how a little change that doesn't mean something to someone dramatically affects somebody else. Somebody allowed the city at one time, and this is back in the 70s, allowed people to make a change that I'm sure that they thought was insignificant, but it turned out to be a major problem for me and probably devalued my house. And I kind of, I guess after that I moved over to Venus, another nice neighborhood, and all of a sudden a guy moved in there and had construction business, and we had stuff all over the neighborhood, equipment. Now the police department, finally took care of that. What I'm saying is I just kind of have the feeling now with this situation that's developing with the change in our neighborhood that I've been here before. I've been in a nice neighborhood that's slowly degraded. And when you take away these protections, this covenant, no matter who's responsible for it and what's been done in the past, when you take away the protection, when you change an ordinance, whatever you do will lead to the degrading of the neighborhood, the lowering of the property values, and it's more than just my restricting our view of the countryside. So I just ask you, please, don't lift the restrictions on our neighborhood, because we've worked hard to keep it nice. We want it to remain nice. We don't want to see it slowly decrease in value and slowly go downhill like so many neighborhoods in this town have. And we all know that's happened. So I would just ask you to work with us and protect our neighborhood, and thank you very much.
Thank you.
My name's Roger Newell, and I live at 102 South Eastbourne Drive. I was one of the original builders, and and that's why we built on that lot. We come from West Republic, a lot of great people there. But as we moved in, the older people that were dying off, those houses were bought up for rentals, like Mr. Nicholson said. People parking their cars on the grass, nothing to prevent this. Okay. But I want to thank you, commissioners, for the opportunity to talk to you. Article 1 of the subdivision covenant states, the general purpose of the covenant was to ensure the subdivision remained desirable and attractive to be enforced by the city of Salina. That's what I and my wife liked about it, because we came from a neighborhood like Rick was talking about. Okay, now, there's quite a few discrepancies that I found tonight that were talked about. And on August the 23rd, 1993, the City Commission gave final zoning and approval of the 25-year covenants, and the covenants were endorsed and approved by the City Commission. That was 27 years ago. Okay. Article 21 of the covenants specifically deals with the end of the 25-year covenants and the beginning of the 10-year extension at said time. At that said time, you could take a vote to remove the covenants in full or in part. No vote was taken in 2018. That was the end of the covenant, not 2019, 2018. Okay? Okay, and it was extended for a 10-year period of time. The date was August 23rd, and no votes were taken, so the covenants were automatically extended and to be enforced. We're now 2 years past that window, and there was no vote to change the covenants. Okay, the Bochlingers purchased their home in 2019. That's way past the time to take a vote. There should have never been a vote. We should never be here talking about this. Okay, they applied for their, I don't know when they applied for their permit, but it had to be after that date. Okay, somehow the city decides to bring this to a vote. Okay, Mr. Andrews set up a time for the voting to be held at the City County Building on August 27th, 2020. He had in his statement there was an opportunity to sign on a rescheduled date if you couldn't make that original date. Okay. There weren't enough votes. They only had 10 votes then. Okay. 2 of the original 10 were retracted. That brings you down to 8. Okay. They didn't get enough votes at the scheduled time or that date. Okay. And Mr. Andrews told me he only witnessed 10 of those votes. So 2 of those votes were retracted. So all the other votes were acquired by Mr. Bottlinger and notarized by some other notary public, okay, rather than the original plan to be witnessed by the city. If all of these votes would have been witnessed by the city, we wouldn't have had the problem that we have with the falsified notary document that the city received. There's been 2 legal retraction letters. And also, I don't know how you could count the vote that the Burgers gave if it, when I talked to the state, they said it's a legal document if it's legally notarized. Otherwise, it's an illegal document. So we have to take the Burgers vote out of that. Okay. Okay. Mr. Berger told me that Mr. Blottlinger came to their house, picked up the paper, left. There was no notary there. He did not know the story. He didn't say there was a notary in the car. He did not know. Him and his wife did not know that there was a notary public in the car. There was no notary public anywhere around. So if these signatures had been witnessed by the city as planned, we wouldn't be looking at this falsified document. Also, there are other signatures that Mr. Andrews showed me. So the other 5 that he got, or 4 that he got, were notarized by somebody else other than the city. 2 of those signatures were also notarized by the person that falsified the Burgers document. So do those votes count? So we got a lot of discretion here, or discrepancies, on how many votes are actually to be counted. So they simply don't have enough
About another 30
votes.
seconds if you could. Yeah, so that's me. Yeah, about another 30 seconds or so.
Okay.
If you could wrap it up. Thanks.
They simply don't have enough votes, and some of the votes they have, other votes may be, signatures may be tainted. So I hope that you take this into deep consideration when you vote tonight, or whenever you vote, that there's a lot of things going on here. I want to thank you.
Okay, thank you.
Mayor and Commissioners, I feel compelled to clarify a few things. As we mentioned, there's not a functioning homeowners association, so we can tell that these covenants apparently have become important to the residents of the subdivision, but they have plenty of options of their own doing to reconstitute the homeowners association, to take recourse in a court of law, and part of the reason that it's not advisable for cities to be parties to homeowners association covenants is the expectations that are being put upon you this evening. Mr. Newell read from section 1 regarding general purposes about it being desirable and attractive, and then he closed that by saying to be enforced by the city.
I was going to comment on that. It doesn't say that it was to be enforced by the city of Salina, yeah.
Thank you for clarifying that, because I was looking at the section and I couldn't see that terminology.
So with respect to enforcement, and this presumption that the city has an obligation to enforce, section 23 regarding enforcement provides that it shall be lawful for any persons owning property in the subdivision or the city of Salina to institute proceedings at law. So in a typical homeowners association dispute, one neighbor would be suing another neighbor. We, by this language, have similar ability to file suit if we so choose. That didn't put us in an enforcement role as it relates to the homeowners association covenant. It didn't create, a positive obligation in lieu of the homeowners themselves. And then lastly, with respect to the dates and signatures, staff was trying to facilitate this process. In order to put a date on it, in order to get it before you, in order to bring it back, we did set some dates. But that's a process of facilitation, nothing more. It was not an ironclad deadline here, there, or otherwise. The individual property owners have plenty of individual responsibility and rights they could pursue on their own, separate and distinct to anything that staff's tried to do to assist them.
I think we've gone down several different roads here and I understand that if the block owners want to pursue something else, they can. But I think at this point, we're looking at what's in front of us today. And it appears to me that I'm going to look at my other commissioners and say, if we consent to accept the 2 signatures that were withdrawn, there's not sufficient signatures to move forward. And that's what we're here today.
That's my understanding as well.
So,
Okay, restate that.
if we consent to accept the 2 withdrawals, the 2
Yes,
that were
okay,
done,
yes.
we do not have the 12 signatures necessary. So all the other conversations we're having do not come into play. And it's nice to have this conversation, but I believe at this point, if we feel those 2 withdrawals are meet our requirements, then I think we're done at this point. Did I state that correctly, Mr. Bingston? I always like to look at legal counsel because I can get myself in trouble.
Yes, I think you did, Mayor.
Okay. So unless there is a commissioner that disagrees with that, I believe that
So the correct action on our
is to do
part
that.
would be to adopt Resolution 20-7894,
No.
which includes,
Would it?
which
Then-
it seems strange, but
Yeah.
it states what you just stated.
Right, it makes findings that there are insufficient signatures
Okay.
to go forward.
That's the conclusion.
Yeah, I was getting confused on that too until I read to,
Yeah, I
to
was-
to the, yeah, until it stated the findings in whatever.
that a
It's
motion,
almost,
Commissioner?
well, it's almost like a reverse proposition in California.
Yeah,
Vote
we
yes to
read
say
that.
no, but,
Okay.
yeah.
Do we have a motion then?
I move
Yeah.
that we approve resolution number 20-7894.
Second.
We have a motion and a second to approve resolution number 20-7894. All those in favor?
Aye.
Opposed? Okay, that passes 5-0. Okay, with that, do we have any other business to come before the commission?
I had just a couple of things. The first is, I just wanted to express my appreciation to fellow members of the governing body for their commitment to wearing masks as we meet, and to staff as well. I know they're not the most comfortable, but I appreciate it, especially in light of the fact that our cases, our COVID cases, are growing exponentially. I had a couple of questions for the other commissioners in terms of, right now, I'm getting, and as I'm sure you all are too, I'm getting a lot of emails about people who are not complying with our mask ordinance. And I didn't, especially like in indoor public settings, and I didn't know if there was any appetite among the commission to either require masks in all public places, irrespective of social distancing, or talk about some enforcement strategies that we can put in place, and we can start enforcing the ordinance that we have. And I'm just looking to get some feedback.
I'm getting some feedback too along those lines. And I was going to ask if we could have a report either this meeting or next meeting on what kind of reports we have had of violations and how we've handled those, and what the nature of the enforcement has been on those. I'm not expecting staff to generate that tonight for us, but I would like to know what we've done. And, you know, I guess the question is if there's an appetite, if I might use your terms, to modify our approach.
Yeah, I think from where I'm sitting, I think it bears some discussing.
Fully agree. Coronavirus is not going away anytime soon, and it's about to be complicated by the regular flu, if you dare use such a term, and what cold weather does as far as pneumonia. Those people who are at risk are going to be even more at risk with the regular wintertime weather coming. And I keep saying, our hospital only has so many beds that can be dedicated to taking care of people sick with this. And, a lot of folks who are in our hospital don't get counted on our county rolls because they're residents of other counties. Other counties send their sickest people here. And we're about to enter just our regular busy time of the year anyway for illness. The building looks large from the outside, but limited number of beds, and even more scary, there's a limited number of people to take care of folks who are patients in those beds. So we need to keep this down. I'd much rather have a 2-year trickle than a blowout party and do it all in 3 weeks, because most of the folks who would show up in those 3 weeks wouldn't make it.
I think the question, if we want to talk about this, the question we'll have to address is how to expand that requirement, because right now, I will say, probably not without controversy, but walking around and looking and doing counts in various locations, there are people who appear to not be wearing masks when they should, but not knowing what exceptions they might be subject to, it's hard for me to judge. But I would say that, the citizens of Salina have done, I think, an overall and admirable job of compliance. It's walking around, doesn't matter where you go, the majority of people who are in positions of being required to wear masks are doing so. The question with requiring masks in all public places at any time begs the question of how do you deal with eating and drinking and a variety of other activities where, I don't know how you do that, Commissioner Hodges, and and how do we deal with exceptions for health issues? There are things that are just problematic with I don't know how you
I'd
deal
have to
with those
reread
issues.
the ordinance, but how does it state on social distancing? Does it deal with social distancing, the ordinance with wearing masks? I can't remember.
If you're indoors, you have to be greater 6 feet or greater apart,
So
correct?
You get into that. I have a real problem with being able to handle, and I would probably go along with you. I would say we have 90% plus of the people that are following the mask rules, and
You guys must hang out with a better class of people than where I'm going.
But again, within homes or within if you're at restaurants, you're not required to wear them. I don't know.
And that's where a lot of cases come from. Church, I'll tell you how ironic it is. 6 months ago, I couldn't go home because Kansas would make me quarantine if I'd been to D.C., Maryland, Virginia. Now I can't go home because D.C. makes me quarantine because I'm coming from Kansas. If you look up the gut of this country, that's where the rates are increasing.
And, and I understand that it's problematic. I truly do. But as I read more and more about this, is we're learning more and more about how COVID-19 spreads in terms of the aerosolized particles, and understanding that we may be in this for another year and a half, 2 years. At some point, I think that we are going to have some difficult conversations about, how far do we go? Do we wait until our healthcare facilities are at their breaking point? And just it's something I think if we could maybe revisit it every few weeks or keeping an eye on the trends, because if we have a few more weeks like we have the last couple weeks, that's a lot of burden to place on our healthcare system. So thank you for.
I just think the enforceability is really tough. I think Jacob, our deputy city manager's been handling those calls and stuff, and.
Yeah, I've certainly gotten all the emails come into my box at facemask@salina.org, and actually it's kind of tapered off. It's slowed a little bit. We actually did write a ticket last week, so this is the first time I've had a complaint that somebody that I followed up with, a business, and said, hey, you need to follow the ordinance, and there was a follow-up complaint about a week later, so we did send a police officer to write a ticket in that case. So we are enforcing it, the best we can. I've contacted many businesses. I don't have a log of, all the places that I've talked to, but I've certainly talked to a lot of businesses. Most of them seem pretty open to trying to enforce the ordinance. I have had some say that all my employees have medical exemptions. So I think that's one of those things that people are at least talking about in the community. So,
is there anything we can do to redouble the public's awareness that we want to reinforce the mask mandate? We don't even have the Salina Journal here this evening, so what options?
One of the things I talked to the staff about Friday was, I think we need to make, if we haven't made it clear, and I'm not sure that we have, that, we'll be nice the first time. As far as educating people, that's kind of what we did with the smoking requirement, is made sure that the businesses and folks understood what the requirement was. But I think once we do that, that second time around, if there's repeat violations, then we have to step up to the first level of enforcement, and apparently we did write a ticket. So, at the minimum, I just don't know, absent, saying we're going to close places down, how you require masks at places like restaurants and bars and other locations like that where people need their, access to their face to do whatever it is that they're doing there.
And I hesitate to offer it up into the collective consciousness, but it's already been discussed. I think the other issue is the medical exemption. And we've looked at that in terms of HIPAA and some other aspects. What we haven't looked at is whether you would have the option to just remove the exemption. If you truly want to put staff in a position to be able to enforce that exemption without any requirement for verification, that exemption ties our hands.
I think I'm the only one that says, yep, go ahead and do away with them. I haven't heard a board-certified physician concur that there are medical exemptions, with the single exception of perhaps something wrong with the structure of someone's face.
I guess we could certainly check the CDC and the World Health Organization, see what their official recommendation is. If we want to, or even our own,
Actually, frankly, I'm looking at it more from a legal perspective than a medical perspective. The question in my mind is whether you have any obligation to provide it. It would be a policy decision for you whether you want to go that far, but if you remove that exemption, then
you can ask, but they don't have to tell you, maybe. I don't know what the legal
I don't know that we're in a position to require them, require proof or verification. So if anything, it would be removing that exemption.
Right now in Kansas, they only have to, the person only has to state that they do have a medical exemption, if I'm not mistaken, and they're not required to tell you what it is.
Well, to say in Kansas, the governor's authority has been superseded. So I don't know that there is Kansas guidance. It's on a county-by-county basis.
Or their recommendations, but...
I guess there's a distinction between recommendation and requirement, but we're kind of on our own as it relates to requirements. If anything, I think it would be questions of HIPAA and then a policy decision for you as a governing body.
Or ADA, perhaps.
Yeah, well, I guess we need to look at that as well.
Yeah, and I'll jump in here a little bit. We did actually have Clark Mize and Linville look at this a little bit, and it actually isn't a function of HIPAA. HIPAA is really more for the health providers. It is a function of ADA, and there really isn't any case law on this at this point. It's kind of too new. So what they've kind of looked at is at the things like service animals. You're really very limited in the questions that you can ask for service animals, and they have found that the ADA rules, the burden on the individual to carry around some kind of proof, that's not something that they've required anywhere. So that's something that we just really don't know what questions we can ask, and we really can't provide them, or we can't require them to provide any kind of proof. So it's pretty hard to get over that burden.
Well, and as clarification, that all relates to a scenario where an exemption is in place, and the questions are what you can and can't ask. The legal question I'm raising is whether you have an obligation to offer up a medical exemption.
Well, I'm in favor of getting rid of exemptions, but I think that's one person isn't going to get it done. So.
Well, and peer pressure. If people stop associating around folks who don't have masks, vote with your feet. You don't want to be on the, I'm a knock on wood, you don't want to be in one of those rooms with those funny looking stovepipes coming out of them at the hospital, because every one of those rooms that's lit up is somebody who's ill with this condition.
If you wish to discuss it further, we can staff it through. I know it's been thrown out, but I'm looking for detailed direction on this one.
I have some folks that I don't claim to be expert in everything, but I know folks who think they're expert in it. I can talk to them.
We can.
I mean, both, and they would have expertise on both the medical and legal, and certainly have opinions or references.
Is there any other? I'm okay with the way we are, trying to enforce what we have, but that's just me. I'll look to my left.
I'm on the same page. I think we're doing all we can do, and we can remind everybody as informationally, but that's as far as I'm willing to go with it.
And we can step up PR. We can get commercials on.
I would have to say that I am caught in between on this issue because I know that the masking does make a difference. But I also know there are limits to how severe we can get as far as nobody wants to shut down again. And I would rather see us try to step up efforts under what we can do now and see if we can make it be a little bit more effective, rather than change the entire structure of the thing and see if we can get results that way.
To education?
Education, follow up with enforcement. When we get reports of folks not complying, I think we need to spend a little effort to follow up on that and, issue the reminder and then,
But I've got to admit, when I'm out in the public, I still think it's 90-some% when I go into a store or I go somewhere, I see people with their masks on. And again, something that wouldn't be enforceable, and this is what I'm looking at, is, there may be a birthday party. And again, this is education, I guess. So I'm looking at Commissioner Davis that, it's in somebody's home, and if they're having a group there, I don't know how we control, I don't know how we can,
That's where education comes in. It just because you're related to them doesn't mean they're not going to make you sick.
And I understand that, but that's what I'm saying, but that's not, but to change, to try to strengthen the ordinance, I don't know.
I didn't mean not in somebody's private home.
Yeah,
I mean, I understand, no, I meant
But you
like
hit
in
them
public.
hard with, that's where the education comes in. Because, the big, there are already recommendations that are out for Thanksgiving because, we thought school opening was going to be a big catalyst. The next big danger zone for this country is the fourth Thursday in November.
Well, this recent growth in cases tracks back to events in August, which had a number of things happening, including schools reopening, some pre-opening activities, Labor Day. There were a number of things, I think, that might have fed this thing. And I don't know how we prevent
You're going
private
to have those with
gatherings
the
and so
holidays
on.
coming up. I don't know
Yeah,
how
it's, the holidays coming up. I just don't know how we affect that because what people do on their own time and in essentially
homes.
private places, we don't have, we have no control over. And I don't know, even if you go to the store, I concur with Mayor Hoppick, when you walk around and look and, I've actually done physical counts and logged off and it doesn't necessarily apply everywhere, but the places I've went, the larger places I've went, compliance has been, quite good. You always see one or two people without masks, but you don't know what the circumstances are, if they're an exemption or not.
And again, if they're social distancing by ordinance, they don't have to.
They're 6 feet from everybody else. I don't know how you enforce it. And if you did report somebody, by the time anybody got there to talk to them, they're likely to be gone. So it becomes very difficult to do that.
But again, education, because the folks who have the family gatherings of Thanksgiving, guess where they're going to be that Monday morning? At your workplace.
Yeah. Speaking of holidays, my question was going to be, have we received any guidance from the health officer relating to Halloween activities?
Not that I'm aware of. Are you?
I mean, that's, you know, there are neighborhoods who churn out the works for this, and that's going to be another case where you have lots of people who don't know each other having contact with each other, and by and large, I don't think the kind of masks that are worn at that event are the sorts of masks that will reduce transmission.
Might have a lot of bandits this year.
Well,
Yeah, I guess.
we're going to get all of our candy, we're going to put them in plastic bags, we're going to have gloves on, and only difference is this year you don't get to choose what you want. Here's your bag, take it or take it or leave
But it still doesn't eliminate the contact.
6-foot pole.
A 6-foot pole.
Okay, anything else?
Yeah, one quick, is there any rough ideas when we will next discuss the thoughts, comments, proposals from the policing initiative?
Yeah, we're going to try to staff it up for next Monday. I'm not sure Chief Nelson knows that yet, but no, I need to coordinate with him further.
Okay.
Well, I'll let you tell him. Okay.
With that, I'll accept a motion to adjourn.
Second.
Motion is second. All those in favor?
Aye.
Opposed? See everyone next week.